Hello and welcome. I am Juliet Rizzo and I will be talking with Sheila Friedman and Ken Keenis from the Office of Special Education Programs, or OSEP, about the final Part B regulations implementing the Individuals with Disabilities Education Act, or IDEA. We'll be talking about the provisions relating to children with disabilities enrolled by their parents in private schools. Welcome, Sheila and Ken, and thanks for being with us today.
Hello,
Hi,
Juliet.
Juliet.
Let's talk first about some of the major differences for children with disabilities attending public schools and those enrolled by their parents in private schools.
I think one of the major differences that parents need to know about is that children with disabilities enrolled by their parents in private schools have no individual right to special education and related services. This is not a new provision under IDEA 2004. It means that these children may not get the same services they would receive if they attended a public school or a public placement at a private school, and that not every parentally placed child will receive services.
That's right. Another difference is that children with disabilities enrolled in private schools selected to get services also don't have individualized education programs or IEPs. Whatever services they are designated to receive are described in a services plan. Services can be provided off-site or on the premises of private schools if it is not illegal to do so in the child's state. Also, any services offered must be secular, neutral, and non-ideological. Local educational agencies or LEAs must hold title to any property or equipment that is purchased with public funds for the use of these children.
Are other long-standing requirements still in effect?
Yes and no. Let me explain. For this population, the equitable services provisions continue to apply, and a proportionate amount of Part B funds must be spent on services. There must be a child find process and determinations regarding types and amounts of services, and locations of those services are made through a consultation process.
So in many ways, the basic requirements remain intact, but there are some major differences that we are about to review.
Is there anything else you want to highlight at this point?
A child with a disability can only be considered for eligibility for equitable services if the child is enrolled in a private school that meets the state's definition of elementary school or secondary school. This change definitely has an impact on preschool children with disabilities aged 3 through 5. Preschool children with disabilities can only be considered for equitable services if they are enrolled in private preschools that meet the state's definition of elementary school, which means a day or residential school that provides elementary education as determined under state law.
So, if the state's definition of an elementary school includes preschools, then children with disabilities, age 3 through 5, enrolled by their parents in private preschools meeting that definition can be considered for equitable services.
Exactly.
Can you talk more about the shift in LEA responsibility for services for this population of children? I understand that this is one of the most important changes made by IDEA 2004.
IDEA 2004 shifts responsibility for meeting all of the provisions of IDEA 2004 that apply to private school children from the LEA where the child's parent resides to the LEA where the private school is located. Under prior law, parents who enrolled their children in private schools, including religious schools, seeking special education services for their children, contacted the LEA where they lived. This was true even if they enrolled their children in a private school located in another school district. Under IDEA 2004, because of the shift of the responsibility to the LEA where the private school is located, this is no longer true. Under IDEA 2004, the LEA where the private school is located is responsible for equitable services and for calculating the proportionate share of federal Part B funds based on the number of children with disabilities attending private schools located within the LEA.
In addition, under IDEA 2004, the LEA where the private school is located is responsible for child find and for the consultation process. Private schools now only have to deal with a single LEA. and while LEAs still must often deal with more than one private school, these private schools are now located within their jurisdictions, and it is logistically simpler, we hope.
Who decides what services these children will get, and how is it decided?
The IDEA 2004 and its implementing regulations require equitable participation of children with disabilities enrolled in private schools by their parents based on a process that includes timely and meaningful consultation between the LEA where the private school is located and representatives of private schools and parents. LEAs decide what services will be provided based on that process. LEAs must also ensure that a proportionate share of Part B funds is spent on these children.
Let me stop you there for a minute, Ken. How do LEAs calculate the proportionate share?
First, let me say that Appendix B of the final Part B regulations provides information on how to calculate the proportionate share. Let me show you an example. If the number of public school children eligible for special education and related services under Part B of IDEA is 300 and the number of eligible private school children is 20, then the total number of eligible children is 320. If the amount of federal Part B dollars that the LEA receives is $152,500, then the amount available per pupil is $476.56. That's obtained by dividing 320 into the 152,500. You multiply the per pupil amount of $476.56 times the 20 eligible private school children, and the proportionate share is $9,531.25.
We all need to remember that the proportionate share does not have to be spent on a per-pupil basis for children with disabilities enrolled by their parents in private schools. The LEA, after consultation, will determine how those funds will be spent.
And an LEA can spend more than that amount if it chooses to do so.
But the LEA cannot spend less than the proportionate share of its Part B funds based on the formula you just mentioned.
So, for example, if the LEA wanted to spend the proportionate share on evaluating children in private schools who might be eligible for Part B services, could they spend it all on that?
Juliet, you just raised a very important point. The cost of child find activities designed to locate, identify, and evaluate children with disabilities cannot be considered in the proportionate share calculation. The idea of the proportionate share is to ensure the provision of equitable services based on consideration of the needs of eligible children who have disabilities. Still, LEAs must engage in child find activities in the private schools to ensure that all eligible children's needs are considered in determining the types of children services offered, and it is important for all eligible children to be counted in doing the proportionate share calculation. There are also other funding considerations. State and local funds may supplement or increase, but cannot supplant or take the place of federal funds used for children with disabilities enrolled by their parents in private schools.
One more clarification regarding the proportionate share. If the LEA has not spent the entire proportionate share by the end of the fiscal year, the LEA must obligate these funds for special education and related services for children with disabilities enrolled by their parents in private schools in the next year.
A lot seems to ride on the consultation process you have mentioned earlier. Haven't LEAs always been required to consult with the private school representatives?
Although consultation has been required in the past, IDEA 2004 is much more specific and has added some new and important provisions around the consultation process. There is now language in IDEA 2004 that consultation must be timely and meaningful, and this obligation rests with the LEA where the private school is located, and in some cases with the State Educational Agency, or SEA. Also, LEAs must obtain a written affirmation from the representatives of participating private schools that timely and meaningful consultation actually took place. If the representatives do not provide the affirmation within a reasonable period of time, the LEA must forward the documentation of the consultation process to the SEA.
And if a private school official is not satisfied with the consultation process, the official can file a complaint with the SEA to allege that the LEA either did not engage in consultation that was timely and meaningful or did not give due consideration to the views of the private school official.
If the private school official is not satisfied with the SEA's decision issued on its complaint on the consultation process, the official can submit a complaint to the Secretary of Education.
What about children in a private school who are attending that school but who live in another LEA or even in another state than the state in which the private school is located? Does the LEA that the private school is in have child find responsibility for these children?
The LEA in which the private school is located has the responsibility for child find activities in each of the private, including religious schools within its jurisdiction. It doesn't matter in what state or district the child resides.
That raises the issue of information sharing between the LEA, where the child resides, and where the child might have been evaluated before, as an example, and the LEA in which the private school is located, where the child now attends school. Can the LEAs transfer those records?
That question came up in the public comments on IDEA 2004. There were a lot of comments requesting clarification of this issue. The regulations clarify that if a child is enrolled or is going to enroll in a private school that is not located in the LEA of the parent's residence, parental consent must be obtained before any personally identifiable information about the child is released between the LEA officials.
That brings up the issue of parental consent for evaluation. LEAs have the option to use the due process procedures of IDEA to obtain consent for evaluation if parents don't provide consent. Is that true for children with disabilities in private schools as well?
The regulations make it clear that if a parent who enrolls or seeks to enroll their child in a private school does not provide consent for the initial evaluation or reevaluation, or the parent fails to respond to the request to provide consent, the public agency cannot seek to force the evaluation by using its consent override procedures.
That brings up another clarification in the regulations regarding due process. There were many public comments expressing concern that due process rights for children with disabilities enrolled by their parents in private schools are too limited. The comments also requested clarification as to which district a parent should file a due process request. The regulations clarified that a parent of a child enrolled by that parent in a private school has the right to file a due process complaint regarding the child find requirements in Section 300.131, including Sections 300.300 through 300.311, and that such a complaint must be filed with the LEA in which the private school is located. Also, a copy of the complaint must be forwarded to the SEA.
And that makes sense when you consider that it's the LEA where the private school is located that is responsible for implementing the child find requirements.
What about issues other than child find?
Due process rights are limited to child find, including evaluation issues. That does not mean that a parent who enrolls their child in private school who is dissatisfied has no recourse under Part B of IDEA. If an organization or individual believes that an SEA or LEA has failed to meet any of the requirements of Sections 300.132 through 300.135 and 300.137 through 300.144, The parent can file a complaint with the SEA using the state complaint procedures found in sections 300.151 through 300.153. This includes child find. In addition, an organization or individual may file a complaint regarding the equitable services provisions, including that the LEA has refused to serve a particular child or has not implemented the services contained in a child's services plan.
Our time is nearly up for today. Are there any major changes or provisions that we haven't talked about yet?
I think another important issue was raised through the public comment process. Public comments asked for clarification about whether private school teachers must meet the highly qualified standards that public school teachers must meet.
And the answer is?
The regulations clarify that personnel providing services to children enrolled in private schools by their parents must meet the same standards as personnel in the public schools, except that private elementary and secondary school teachers who are providing equitable services to parentally placed private school children with disabilities do not have to meet the highly qualified special education teacher requirements of Section 300.18. So, if the responsible LEA contracts with private school teachers to provide equitable services to children with disabilities enrolled by their parents in private schools, those private school teachers do not have to meet the highly qualified special education teacher requirements. But if public school personnel provide equitable services to private school children on or off the premises of the private schools, those public school personnel must meet the same personnel standards as other public school personnel.
Thank you for that clarification, Ken.
I think we have highlighted the critical issues. Interested individuals can find more information on the IDEA website.
Remember, the website is found at idea.ed.gov and includes a question and answer or Q&A document regarding children with disabilities enrolled by their parents in private schools. The current document addresses statutory requirements but will be updated as soon as possible to reflect the final Part B regulations.
Thank you, Ken, and thank you, Sheila. I appreciate your being here today to talk with us about these important provisions. This video is one in a series prepared by the U.S. Department of Education, Office of Special Education Programs, to assist our stakeholders in better understanding some of the significant provisions of the final regulations implementing IDEA 2004. We hope you found it helpful, and we thank you for your attention.